experts who answer some of the questions that people send in to our website, Maria Horitzau from Crossland Solicitors. Welcome, Maria.
Thank you. Glad to be here.
So Maria's going to answer all your questions on flexible working legislation, what you can do, what you can't do. Ooh, recording has stopped. And then we're going to sort of, and throughout you can ask your own questions on the chat, and I will put those to Maria. So please do enter them in the chat as we go along, and I'm sure you've got loads of questions. So without further ado, I'm going to kick off with the first questions, Maria. So first of all, I guess is important to know what the law is now with regard to flexible working. What are people's rights and how should they go about requesting flexible working?
So at the moment, any employee who has more than 26 weeks or more service with the employer can make a formal flexible working request once each year. Now that under the rules of the legislation now, that can be about changing your hours of work, the days that you work, and also changing the place of your work between the office and your home place. Those are strictly speaking the only three grounds or the types of change that you can request. But of course, an employer can include different types of requests in their flexible working policy, and you can always ask for additional ones. In terms of the process, the employer has 3 months in which to give that proper reasonable consideration, and then to make a decision. It can feel like quite a long time, Mandy, but actually by the time that you get the formal request in, maybe you've had a meeting, maybe 2 meetings with your employer, and then you get the decision, and maybe you're not happy with that decision, you might want to appeal. That 3 months can start to feel quite short, and it can be extended by agreement.
Right. And are there any, I know that employers can turn down a request, and there's several different reasons that they can turn down a request. What kinds of reasons are there? Are they quite broad ranging, I think?
Yes, that's right. That's right, Mandy. They're suitably generic that an employer can basically can identify them. There are 8 in total, and they include the burden of additional costs, the detriment to meeting existing customer needs, detriment upon the existing staff, their ability to recruit additional staff, and detriment on quality, on performance, and potentially also if there's any planned structural changes. Now that could be things like upcoming restructures or redundancies that you may not actually be aware of, but there were 8 specific reasons that the employer must base their decision or must reject a decision on. They can use 1, they can use 2, or they could use all 8. And a sensible, reasonable employer who is unable to agree to a flexible working request will not only tell you as an employee which of those reasons that they're basing their decision on, but also give a wee bit more detail about why, because that allows you as an employee to understand their rationale, and if you wish then to appeal that decision or to potentially to suggest alternatives. Again, that's good sound business advice, but we don't always get that.
Yes, that's not. There's no sort of right to appeal, is there? There's no. It's only kind of good practice. It's recommended.
That's right, Mandy. So what we have is the legislation that sets out the process, and it doesn't itself give a right to appeal. But we also have the ACAS Code of Practice on flexible working, and also guidance. Now, the ACAS Code of Practice actually does have legally binding effect. So if you are the employer or the employee, it is very sensible to go in and read those both before you make a request or decide a request, or during that process, because the ACAS Code of Practice, as you quite rightly say, does say, look, to employers, you've got to give reasonable consideration to a flexible working request, and that will potentially include, or should we recommend include, an appeal. So it's very sensible to do that as an employer. And to be perfectly honest, I do a lot of contract revisions, a lot of policy reviews, And we would always recommend including the right to appeal.
Yes, yeah. And so talking about returners and people who are returning to work, at the moment, the law, as you said, you have to be in your job for 26 weeks in order to actually have a legal right to request. You could always try and negotiate that from the offset, but there's no legal right to that. But the law is changing, isn't it? And when is that likely to change, and in what ways is it changing?
You're absolutely right, Mandy. It is coming up. So the government have passed the legislation, but we're just waiting for it to come into force. And we anticipate that going to be sometime between spring and summer next year. What that's going to mean is, and again, we anticipate more ACAS, a code of practice from ACAS, which will hopefully flesh out things. But the key things to bear in mind is that it is going to reduce the amount of time that an employer has to make a decision from 3 months to 2 months, which is potentially really helpful if you are planning a return to work and you need to make arrangements. I certainly am not the only person who's coming back from maternity leave and you think, actually, you've got to get a childcare booked, you've got to get it organised, and you can't, so the 2 months would be really helpful in being able to drive that decision making forward. So we've got the reduction in time. There is no right at the the key thing I think that we're seeing a lot in the press is about the idea that this could be a day one right under the legislation. That's not in the legislation, but I think that what we'll see is that there will be a drive by most employers to certainly consider doing that, and it may be encouraged. It's different for people who are working in the NHS. That is a day one right already. The other thing I think that's quite useful is that there is going to be an obligation to consult with employees. So not just so one of the things that we sometimes hear is that an employee has put in a request and they've followed the form, they've filled out the relevant form, they've told the employer about how it might affect their business and the team and what they could do to alleviate that effect. And then there's just a blanket decision is made. And the employee they don't have a meeting, they don't have an opportunity to thrash out any concerns or issues. And that's going to hopefully change. As I say, we don't have a great amount of detail. It's just that the obligation is going to be to consult. How far that will go is not known at the moment. The other thing I think is quite helpful is that at the moment we've only got the right to make a formal request once a year. That's going to change to twice a year, which I suspect might help a lot of employees where they're asking for perhaps temporary changes, or things change very quickly and they or they need to, their request is rejected initially, and then they're able to review that and make an alternative tweaked request. So those are the key things that are going to change. And I say next, looking at certainly spring, if not the summertime.
Yes. So that's really interesting because, as you say, the press has been all about day one right to request, but actually they're saying that they're going to introduce that in secondary legislation, and we'll wait to see that they're going to. They've said that they will. So let's see, but we're still not sure what that actually means. Day one right to request. Is it from interview? Is it from your first day in the job? So you have to take the job and then hope that you do get the flexible working on the first day. So that's quite difficult in terms of childcare arrangements and all that kind of thing. Yes. But the interesting thing is that whole issue of the twice a year thing, because one of the we always balance up whether it's a good idea to do a formal request, and that obviously has really good things for kind of guaranteeing your rights. You have, your contract is changed, isn't it? Or an informal request where you can actually tweak it, but the employer also can do that. So if you've got an informal request, you don't have as many rights at all, do you?
That's right. Yes, there is no framework for that. Now, Mandy, I'll be perfectly honest. I would normally recommend that somebody, if you're thinking about making a flexible working request, go and have a chat to your manager or the HR team to understand essentially whether or not you could even do an informal trial period, which would then, of course, Because if that works and everybody is happy with it, that allows you to use that to back up your formal flexible working request, or you might not even need to do it. It might just be agreed as a permanent change. But I think also having that informal chat first is very helpful to help us as employees and to understand what the concerns are. And we need to fill that. We need, at the moment, under the current regime, we have to identify what those effects could be, how it might affect the team, affect the business or the organization, and what can be done to alleviate that. So if you know already, because you've had an informal chat, you're already ahead of the game, hopefully. I say this, hopefully.
Yes, yes. It's that whole kind of negotiation process, isn't it? That it's got to be good for you as well as it's got to work for the employer and everything. With a trial, if you do suggest, because we sometimes suggest to people to ask for a trial, and we get sort of questions coming back where somebody said, well, I did the trial and then they, you know, it was just kind of token gesture. They took it away after a review. Is it important to sort of ask for some sort of guidance on what a review actually means? What are they actually reviewing? Because if they're just doing it as a kind of tick box thing, you need to know that, you know, there's some substance behind the review, that the review is actually looking at something, you know, how well it's worked.
Yeah, absolutely. I think this, I mean, let's take a step back, you know, and think, you know, the whole purpose of a trial is to see if it works for both the employee and the employer. And a review is only going to be useful if everybody goes into it knowing what we're looking at. So absolutely, I think that's very sensible to understand what it is we're reviewing. But when that's going to happen, and actually I would almost go further and say, let's have a mini review. If it's a 6-month PIT trial, to have it at maybe 2 months and 4 months, so that you understand, both as an employer and as an employee, what's working, what's not working. And that's all part of that relationship, and that, you know, that we have as employees and employers. But it also makes it ultimately for an employer to say at the end of the trial period, this hasn't worked, because you've been working with them throughout and you know exactly how things are going. And I think that the trial period, to be perfectly honest, I mean, I think that if an employer has done the trial period and you as an employee believe that everything's gone fine, you've had positive feedback, obviously you're keeping a copy of those emails or successes that you can point to, that actually potentially makes it harder for an employer then to be able to justify rejecting your flexible working request. If it's worked for 6 months and suddenly on 6 months plus 1 day, the employer says, no, this hasn't worked, there's something odd going on there.
Yes. Yes, absolutely. It's really important, isn't it? In terms of the sort of things that you see as a lawyer, what do you think, where do you think sort of people, where do you think there are some sort of misunderstandings? I've certainly seen it from our point of view, that where people think it's a right to have flexible working sometimes rather than a right to request, and that there is this negotiation process and you have to, it's a two-way thing. Do you have to, and also is it things like people ask, you know, but I've said that my childcare is, you know, whatever, and I can't do it. Do you have to, is it a good idea to say, you know, what your childcare issues are? I don't think you have to, according to the law. You don't have, because anybody can request flexible working, right?
Yes.
But is it a good idea to say that because of other secondary legislation that you might be able to use?
Yes, so I'll take that back to front, if that's okay. I personally think that it is incredibly helpful as an employee and as an employer to set down exactly why, if you want to disclose that, but to identify why this would help you continue to be an engaged employee and to motivate you in your work and your engagement and your work and your support of colleagues. I think that as you've noted, ultimately, flexible working legislation is not particularly, it doesn't have particularly big repercussions for an employer if they get it wrong. If they reject, you know, at the moment, if the employer has not followed the statutory process, if they have if they have not made the decision, you go to tribunal, you get a declaration, and you get 8 weeks pay, which is capped at the moment at £643. That is not a huge amount of money. But actually, in reality, as you've mentioned, Mandy, the reality is that generally when there are issues, it's because the flexible working request has been rejected on discriminatory reasons. So indirect discrimination, because the majority of women have childcare responsibilities, and therefore it could be indirect sex discrimination, or because they've rejected making a reasonable adjustment. So we're looking at disability discrimination. And so actually, as a legal advisor, what we tend to see is that employers need to be very mindful of why they are making this decision. Is there a possibility of it actually being discriminatory? And as an employee, when you're making that flexible working request, I think that, again, as you've said, you don't have to give them information. But if you have a disabled child who's a dependent, and that's why you're making the request, tell them that, because not only is it a lot easier to have a frank conversation with the employer, they may have more sympathy. They may even be able to identify other resources that they can provide to you as a way of support. But also it flags to them, if they have sensible people internally or good legal advisors, that there is potentially a risk of discrimination, of a discrimination claim. And that's what nobody wants to go down that route. So I would be inclined to do that. So and then the first question you had said was about misunderstandings. And I think you absolutely hit it on the head there. It is a right to request. It's not a right to insist on it. And I think that's, and we also, as employees, we have to bear in mind that the employer has a business or an organization to run. They have their own needs commercially, operationally, and sometimes, unfortunately, it's just not possible to accommodate everybody's flexible working request. There might be an alternative. I think that's one of the things I would say, Mandy, is that for both employees and employers, set down perhaps your starting position, your preferred outcome, but be amenable to considering alternatives and to negotiating and working with each other to find a way that works for everybody.
Going back to that thing about discrimination, does that mean that dads don't have as much, because the law is assuming that it's mothers that look after children, so it's kind of entrenching that it's useful. It's useful if it does it discriminate against dads?
Potentially, but that is, I mean, things may change. We are seeing more men who are making flexible working requests, who are having the bulk of childcare commitments or responsibilities. So that may change, but at the moment, the presumption is that it's primarily sits with women. Now, what I would say is that if you are a father or a man and you see all of your female colleagues having flexible working requests being agreed because they're all women and they have childcare commitments, this is making huge presumptions. If you think that all women are getting their requests agreed and that men are not, then you potentially you could argue there that there is some discrimination going on. Probably the easiest way to make sure that you have grounds for that is that you put in a flexible working request, get it rejected, and that the female colleague puts a request in that's exactly the same, for example, and they get it accepted. And then you've got the tangible evidence. Now, I say that all with a caveat. Employers they do have organizations to run, and they should be looking at requests on a case-by-case basis. And it's not necessarily a surefire winner if that does occur. But it's just, as you say, there are men who are making flexible working requests, and they should be also treated reasonably and fairly.
Yes, because that whole issue of the case-by-case scenario is something that comes up a lot with us as well, because people will say, well, so-and-so got it, then why are they rejecting it for me? But they don't have to, it's not that they've set a precedent necessarily, and then they have to give it to everybody else that comes afterwards. is it?
Yeah. No, that's right. I mean, if we think even about the most straightforward example is if everybody asks for Fridays off, and Friday is your busiest day as an organization, it's you're going, the business is not going to survive. So that there are it does need to be dealt with on a case by case basis. Nobody has priority. I think that's really important to make clear. So if you childcare commitments do not trump somebody who has an elderly parent who needs to be cared for, and that does not trump somebody who just wants to have a longer weekend. We all have the right to make this request as long as we make it within the statutory framework, and it needs to be given reasonable consideration.
Yeah. Great. Well, we had a question in here. It says, as someone who's currently seeking work, I'm finding there's less and less flexibility from employers with regards working either hybrid or remotely, with many now insisting on working on site, which is definitely something we're seeing. This goes for both full-time and part-time roles. As someone with a young family, how can I navigate this? What are my rights for requesting to work from home for a portion of my week?
I suppose the right to request is only going to currently kick in from week 26 of your employment. So at this point, it's and I'm saying this is like there are quite a lot of companies who actually have already introduced it as a day one right, and they typically will make that very clear on their websites or through their and through LinkedIn profiles and so on. So that's definitely worth looking at and doing your research on the company, which I'm absolutely sure you are. In terms of requesting it now and in those interview stages and just before, it's all about the negotiation. And I think that really, if you were able to almost present a business case almost to them to say, look, this is what I can do for you. And give them the reassurance perhaps to say, actually, well, on the days I'm working from home, for example, I will have a dedicated workspace. I will be available, I can log in on a bit earlier, or maybe work in the evenings. So you're making it more attractive to them, but ultimately it comes down to negotiation, because at the moment we just don't have this right to request it from the very beginning of our employment.
Yes. That whole issue about people being called back into the office for more days, that's a very tangled legal one, isn't it? So somebody's been allowed to work from home for the last few years and then they're called back into the office. What is their legal standing? Can they say by dint of custom and practice, I've been doing this for several years, you can't change this, you have to negotiate with me? How does that work?
I'm afraid that ultimately it comes down to what's in your employment contract. Now, every employee, let's be very clear about this, every employee should have an employment contract from day one that sets out very specific information. And there's I think it's roughly 24 or 25 things, and it's all the things you would expect, what you're employed as, what your salary is going to be. But most importantly, for these purposes, it's where your normal place of work is. And that should absolutely be in that contract. So go back to your employment contract. If your employment contract says your normal place of work is the office, then that's your place of work. That's your permanent place of work. If you have been permitted to work from home or a different location, whether it's for a month, 6 months, or indeed since COVID, that unless there's been some change, some recognition in writing that your contractual term has changed, your office is the normal place of work. Because I'm going to sound, sorry, my apologies for sounding really legalistic, but ultimately an express written term in your contract cannot be overridden by custom and practice. So that's why if you're in that situation, Mandy, is I think go back and look at your employment contract, go back and check if there's been any emails, notices, anything that allows you to say, actually, on the as of this date, it has been accepted that my working arrangement is going to be on a hybrid basis, and my permanent place of work is going to be split between home and the office. If you don't have that, then the employer has the contractual and legal right to bring you back in. Now, of course, you also have the right to say, that doesn't work for me, but
Yes.
that's the legal position.
Yeah. Interesting. So there's a lot of people in that position now. And I think a lot of people who've actually moved on the back of COVID, moved further away, and then they're facing, you know, bigger commuting costs as well. And obviously childcare costs and things like that.
Yeah.
So and what is the position of the employer? I mean, I don't suppose they have any legal obligations to help with, you know, travel costs or anything like that. If somebody's having to come into the office maybe just one day a week, but they're quite a long way away, unless it's in their contract.
Yes, I know I keep coming back. It is ultimately in the contract. And you're right, Mandy. Unfortunately, there, you know, for as an employee, if we have moved a long distance away from the office, we've made that decision on the basis that we know that our permanent place of work is the office, and we might be called back in at any point. Now, again, we are in a market where employers desperately need to hold on to really good talent and to attract good talent, good hires. So again, I would always suggest going back and having a conversation with your employer. It may be that you are able to, I know, and this may seem very optimistic for many employees and employers, but maybe there is a middle ground. Maybe there is a way of saying, look, I will, you know, I'll come into the office one day a week, but if you could make a contribution to this, or you know, or come into a different hub. And because you're probably not the only employee who's in the same situation, and that's what we're seeing a little bit more now, that as well, that some employers are saying your normal place of work is perhaps London, for example, but we will have a hub in Manchester, and anybody who is in the local area will come into that location rather than coming to the London office. So maybe there is a way there too, so you can show that you were engaged and you were motivated, but without perhaps the significant travel costs that you'll incur otherwise.
What if the employer then suggests, which I've seen, that you maybe take a pay cut to work from home because you're not having to pay, you know, the travel and all of that kind of stuff?
Yeah.
What is your legal, I mean, I guess that's something that you have to decide whether you're willing to do. But I know that some employers have actually tried to introduce this, or are thinking of introducing pay cuts for people who are working from home. What's the law on that?
I'm afraid I'm going to be very boring and say, look back at your employment contract. Your employment contract says that you get paid this amount of money to do your work. If the employer wants to change that, they need to, well, they should be getting your agreement to it. They should not be imposing it. That would be a breach of contract. And you could also potentially bring a claim for unlawful deduction of wages. Or it's going to end up, you know, I mean, you could also claim constructive dismissal if they just unilaterally did it. But what would tend to happen in this case, and again, the recommended approach for employers would be to talk to employees, consult with them, and if they're not able to get agreement, then we're looking at potentially a dismissal and offer of re-employment on the same terms, but with that reduced salary. So I think again, it's legally, it's just not, it's not permitted, it's not possible just to make that reduction and in salary without agreement. But it's, I think as employees, we'd always say, look at this cost savings that you were having from being able to work from home, and at the salary cut that's being proposed, it may be that actually you're in a better situation anyway, and it doesn't make a huge amount of difference, but it may be that it does make a huge amount of difference, in which case, again, talk to your employer.
Yes, it's very much about this negotiation process, and it's so important, that bit at the beginning when you start a job, to actually get the terms right for you. It's worth, even if it seems like a bit of a battle, I guess. I
think yes, absolutely, that's it. And if there's any change that is agreed on a permanent basis, get it written down, get everybody to make sure that everybody is signed it or emailed to confirm that they accept it, and have a copy. Because I'll be honest, Mandy, that's my biggest concern for employees and employers, is that sometimes we don't have the paperwork to back up what's been happening in practice. And that makes it harder to untangle and then to look forward to what we want to achieve.
On the custom and practice issue, which is quite complicated as far as when I looked at it, so none of these kind of things, like if you go down the informal route and you've negotiated that or you do sort of regular overtime, or that kind of thing, does that ever come under custom and practice, or is it, if it's not in your contract, it's not?
No, it can do. No, Andy, and you're right. It is. I mean, there are lots of things that can be implied. They become implied contractual obligations on the employer and on the employee by way of custom and practice. And what we mean by that is that it's something that has been happening regularly, that you are aware of or anticipate happening and continuing to happen. The phrasing is, it's become notorious, which always makes me smile when you have a judge saying that. But things can become contractually binding entitlements or obligations through custom and practice. It's just that if your employment contract says something very different, that it's going to be incredibly, you're on a bit of a sticky situation. So you were talking about pay additional overtime. Most contracts will say that you will they'll account for overtime, again because we've had that the Good Work Plan a few years ago, which said employees are entitled to understand what their terms that apply to them and what is expected of them. So your employment contract should say you are expected, or you may be required to work overtime, and it's going to be paid at a rate that we'll agree or that is set. And if you are consistently and regularly working overtime, that will most likely become an implied contractual right.
Yeah. Because it often says in the contract you may be occasionally asked to do whatever, training at weekends, or or that kind of stuff is another thing that comes up for people, because then they've got to get childcare, and it's quite a difficult thing. But if it's in the contract, you haven't got much hope, have you?
I think it comes, as you say, this is why I recommend strongly that everybody reads their employment contract. It doesn't matter whether you're the employer, because as an employer, you've got to make sure that reflects what you want and what you need from your staff, but also what you've agreed as part of the negotiations, that when somebody starts or when they're promoted. And as an employee, we've got to understand what's required, and definitely ask questions if you're not sure about something that's in a contract. Ask the question.
Yeah, definitely. In terms of the kind of cases that you're seeing, do you see many related to flexible working? Has there been an increase because of COVID? What's going on in the legal world?
There have definitely been more grievances and concerns raised about flexible working, and particularly about working from home. But as I mentioned, they primarily come down to, is this potentially sex discrimination, reasonable adjustments, constructive dismissal situations? So that is so they're part of a bigger picture, so that we're seeing.
Yes, it's very interesting, because what we're seeing, isn't it? Because at the one hand, there seems to be kind of a bit of a backlash against remote and hybrid. The days seem to be creeping up in the office, but on the other hand, there's all this worry about long-term sickness and trying to get people back into the workplace, and talk about kind of the modernization of the workforce because of flexible working. So they seem to be wanting to play it on both sides, have their cake and eat it. Some people have to go back into the office, but other people just have to be, got back into work. Yes. I think that, my view of it is that we go to work to do our jobs. We get paid for those. We expect and we deserve to be treated as an employee with fairness and respect and dignity. There is, as an employer,
we all recognize the employer has an organization to run. They have commercial and operational needs that need to be met, customers, suppliers, whatever it is that their sector is devoted to. And it's supposed to be a relationship. It's supposed to be a positive relationship, or at least one with respect in it. You know? So I do think that I think that we're in an era of change. COVID has changed things significantly. If you had asked me pre-2020, we're all going to be working remotely, or at least on a hybrid basis, I would have been very surprised. I don't think I would have believed you. Whereas now, actually, I think the pendulum has swung completely. During COVID, we were in a period of very extreme situations. And now we're trying to find our I think, middle ground. And what's going to work for one employee and one employer is not necessarily going to work for everybody.
Yeah, absolutely. And we're still in this kind of period of great volatility, aren't we? And then there's there's climate change issues, yes. Technology advances, and it will be even better at doing remote and all that kind of stuff. It's all going to be in the metaverse or whatever.
Yes.
my kids gaming will be actually an advantage for them, that I'm trying to get them off doing all of that stuff. They'll have to teach me how to do all of those things. So yeah, yes. It's really, really interesting.
Yeah.
Have you actually had, this is sort of my final question, have you ever had a case that's gone to the tribunal that's solely on flexible working that's been successful, or is it usually with these other sort of discrimination sort of issues and things?
Yeah, it is. I have never had a case go to purely on flexible working, because the potential remedies are just it's not worth it. I mean that the employment tribunal system is fantastic. It is an opportunity for employees. They can represent themselves. They have access to justice. But it is, I don't think that as an employee, frankly, getting 8 weeks capped pay and then having to go back into the workplace is a particularly nice place to be. So in my experience, Mandy, when I've had cases, flexible working has been is part of a bigger picture. There's been indirect discrimination. That's the primary driver, or a failure to make reasonable adjustments in disability discrimination. And actually, Mandy, there was, I think there was a lot of press coverage, because it might even have been 2 years ago. There was an estate agent case. And the lady in question had been a very loyal employee, and had put in a flexible working request asking to finish an hour earlier, and so that she could collect her child from childcare. She'd made assurances that, for example, she tried to work with the employer and said, I'll be available on the phone during that time. I can make up extra time, or I can juggle the hours around to suit you, but I just need to make sure I get home to get the child. And the request was rejected. Now, at the time, we had a lot of inquiries from both employees and employers because of the press coverage that generated, because the individual in question had been awarded over 22 months earnings as compensation. So it was in excess of 134,000 from memory, which is a very significant amount of money. But when we looked at it, and this is something again that I think drives a lot of the claims that you do see, the individual's compensation was primarily relating to, it wasn't about really the flexible working, as I said, that was capped at the 8 weeks. Her main driver and the main reason that the claims that she succeeded on were sex discrimination, for which she was awarded just shy of £14,000, which is the average award that's given. But again, I'd love it if somebody gave me £14,000, but it's not going to change your life forever. The rest of it was in relation to how long it would take her to find something similar. So just calculate it on fair dismissal compensation award figures. I think that that's what we're looking at. If you are an employee and you're looking at, why has my request been rejected? Look wider. Listen to look at the feedback that you've been given. And I know that we've talked a lot, and I know that
Yeah.
Amanda, you've mentioned a lot about negotiation and having a conversation with your employer. But if you're in that situation and you think this has just been rejected out of hand, look at the wider situation and what's happening to others as well as you. This is you can always do a subject access request at any point as an employee. It is essentially a right that comes from the Data Protection Act and allows you to ask the employer for any personal data that they hold on you. So that can be quite helpful. But I mean, sorry, I'm getting a wee bit distracted and off on a tangent there about potential litigation. So my apologies.
And also take notes of this is something that I learned from hard experience. Take notes,
Yes.
have negotiations with your employer. After you come out, write down, you know, if they said anything that's detrimental, or, you know, like a sort of throwaway remark about, you know, women as such, you know, difficult or whatever it might be, write it down.
Write it down. And also, if they send out notes after the meeting and you don't agree with them, change them. Don't wait, just change them. Just go back and say, I don't agree. They don't have to accept your changes. And that's something that when we advise employers, they say, oh, do I have to accept all the changes that the employees made because we don't agree with them? An employer doesn't have to accept your changes, but they should be keeping a note on file that you have made change of your changes. And you as an employee should be keeping that as well. So I'm afraid it sounds really boring. Look at your contract, keep everything recorded, and keep a paper trail.
Yes. And we've had one more question in the chat, which is a really good one. It says, with working from home, there seems to be less flexibility with illness. For example, colleagues with COVID are expected to work from home. What's the legal standpoint on this? Can they be made to work even though they're feeling dreadful?
No. Sounds a little bit like slavery, doesn't it?
Yes, yeah. Have a right to be sick.
Plus as well that I don't know about anybody who's on this, or you, Mandy, but when I am really unwell, I would be worried about giving advice or my engagement. So about the quality of work that I do. So let's look at this. If you are sick and you are too unwell to do your work. So if you were going into the office and you were too unwell to go into the office, you should be recovering and looking after your health. You should follow the sickness absence policy, make sure that your employer knows where you are, what's going on, and when you're potentially able to come back. If you are now, and COVID and flus, sometimes when we have COVID or illness, we may feel well enough to work. And if you feel well enough, but perhaps your employer has said, don't come into the office, there's somebody with who's vulnerable, and you're still positive, testing positive for COVID. If you're well enough to work, then yes, work. And what I would say is that make sure you tell your employer that you're working, because there is a risk that we want to clarify and be very clear on whether that time is being treated as sick leave or working time, because that there, and we, Mandy, this, like you may only get a limited amount of sick pay. It might be only statutory sick pay, but it may also go into other absence related processes or bonuses, for example. So just be very clear with your employer.
Yes, that you are working rather than you're not. You're either working or you're sick.
Yes.
And do unions, there's a question here, do unions have much influence? I guess it depends on the union and depends on the sector, how much influence, but it's, if you're struggling or you've got some sort of legal issue with your employer and you've got union representation, that's always a good source of support.
Yes, I'll be honest, one of the first things that I ask anybody who calls me up and says, I'm an employee, I've got an issue, is, are you a member of the union? Because if you're a member of the union, you're paying your subscription fees. They are there to support you as an employee, and they can also represent you or come with you as a companion to meetings. But they also, and maybe this is particularly with some of the bigger unions as well, they will have resources that are there to support you on an emotional and personal level. So that, you know, unions can be very helpful. The union representatives often have experience of the processes. They've had some training. They know what to expect. So they can be there very good, even just as somebody sitting in the same room with you as a source of support, or to take notes. You don't even, you know, you might feel quite comfortable having the conversation, but it's nice sometimes just to have someone then there who can also debrief with you afterwards. Or they can, you know, so they're useful. Now, in terms of the influence that they have in respect of flexible working requests, they may have a far greater understanding of what has been done before, of the flexibility of the organisation, and they may also be able to help you to adjust or tailor your flexible working request, or indeed to push back and query things if they think that's a different answer to what we've had 2 weeks ago for somebody else, for example. They and in terms of employers who have recognised unions or have collective agreements, the unions do have influence there in terms of drafting and operating flexible working policies and procedures. So if they're in your workplace, go and talk to them. Even if you don't become a member, go and find out what they do.
Definitely, that's definitely my experience. I had somebody come into a meeting with my boss and his deputy, and it was quite an intimidating sort of situation. And if I'd just been there on my own, I think I would have crumbled. But the union person just asked some of the questions. It was just so nice to have somebody on my side.
I think that's the thing, isn't it? Because we I suspect that we make it sound a wee bit easy, go and have a conversation, and so you're right, Mandy, it's not always easy to do that, especially if you're disclosing personal information and you're a private person, for example, or if you're asking questions that you feel are quite searching, or are more investigative than you would like. And I don't think I'll be honest, many employers don't want to create a hostile or negative environment, but they do need to understand and have that conversation with you. But I think you're right. The other thing I think about the union is that sometimes when we're given the right to bring a companion, and again, your employer should tell you that. If you're not sure, go and have a look at the ACAS Code of Practice and Guidance, before that, look at the policies internally. But sometimes when we've got that, we've been told we can bring a companion to this meeting, that is going to be a fellow worker or a trade union representative. Some of us don't feel entirely comfortable either asking another colleague to do this for us, or sharing that information with them, especially, depending again on the information that's being shared in a conversation. So the union rep can be very helpful in that respect.
Definitely. It can feel really uncomfortable to kind of pull somebody else in, if the environment is quite a hostile environment in the workplace. You don't want to put them, ask somebody to put themselves on the line for you. So that's really useful advice. Yeah. Thank you so much, Maria. It's been really good talking to you. We've gone through lots of different sort of things from the past, the future, and the present and the future. This recording will be put on the website on Monday, and we'll be sharing it with everybody who's registered for this session anyway. We'll be emailing that to you. And we have another session coming up in very, very shortly at 11 with VirTalent, which is about becoming a virtual assistant. And yes, I just wanted to say thank you once again to Maria. And if you have any questions for Maria, we have you can email in any particular questions about your own circumstances or whatever. And Maria is one of the lawyers that we who do great work answering questions, and it's really, really useful. I've been in that situation, and just to have somebody tell you what the law is so comforting. Thank you. Maria.
Thank you for having me today. Thank you for everybody listening to me.
Brilliant. Thanks.